I did briefly mention in my last video that Deborah Rogers apparently is in jail for 7 days for her continuing contempt. However, in addition, I have to bring you some documents that she filed on the 22nd of August regarding a petition in error in the Supreme Court of the Cherokee Nation. So this is an appeal, and the document has been scrolling as I've been speaking. We can see it was filed by Deborah Rogers pro se. There is a certificate of mailing that is unsigned. However, it does appear that this made the court record. Okay, I'll read this next bit. Petitioner Deborah D. Rogers was arrested on April 7, 2021 and incarcerated. Upon release, the case was transferred to the Cherokee Nation District Court, in which she was charged with 3 charges. Petitioner requested a change of venue and it was denied. Petitioner then filed motion to dismiss, which was also denied on August 12, 2022. Petitioner filed a motion to stay the further proceedings to allow the opportunity afforded by the court rules to appeal. The stay was also denied. Petitioner is requesting appeal to the Supreme Court of the Cherokee Nation. The next part of this document is the denial by the court of her motion for want of jurisdiction, which we have seen before. Right, and these are the issues that she wants to be raised on appeal. 1. Did the Curtis Act have the effect of eliminating tribal courts and rendering Cherokee law unenforceable? 2. Did the Curtis Act place the supervision of tribal courts in the hands of the federal government? 3. Did that create a situation where there were concurrent jurisdictions between federal and state governments to the exclusion of a defunct tribal governments? 4. When the Oklahoma Indian Welfare Act was passed in 1936, it became possible for Indian tribes to obtain recognition by the federal government, and after compliance with the OIWA provisions. Was federal approval of tribal governments possible? 5. Did the Cherokee Nation of Oklahoma avail themselves of the opportunity to organise a government under OIWA legislation? 6. The United Kiowa Band of Cherokee Indians in Oklahoma tribe did avail themselves of the OIWA. Did the UKB cooperate with the OIWA in the development of a constitution, bylaws and federal corporate charter that became effective in 1950? 7. Did the federal government, acting through the Secretary of Department of Interior, approve the UKB organisation of government in 1950? 8. Has the UKB operated as an acknowledged and approved government since October 3, 1950? 9. When the federal government organised a process under 25 CFR 83.4 (b), did the CNO take advantage of that opportunity to organise a government? 10. Did CNO attempt in its 1975 constitution to create an appearance of continuity of governance utilising the Constitution of 1839 in order to qualify for the government organisation promulgated under 25 CFR 83.4 and 83.11? 11. Was the Constitution of 1839 rendered ineffectual by the Curtis Act? 12. Did the Bureau of Indian Affairs Commissioner Morris Thompson have the authority to authorise a referendum in the 1975 Constitution? 13. In the 1976 referendum called to ratify the 1975 Constitution, how many adult eligible citizens of the CNO actually voted in that referendum? 14. What percentage of the Cherokee Nation population participated in the 1976 referendum? 15. In the 1999 Constitution, what percentage of eligible votes was called for by the provision in the Constitution regarding the number of eligible voters necessary to vote in order for there to be a ratification? 16. If the 1999 Constitution's provisions provided for 15% of the adult voting population to vote, Was that in violation of the provisions of the OIWA 5203, which required 30% of the adult citizens to vote? 17. What was the number of actual votes and what was the number of the actual population of the CNO when the referendum was conducted in the early 2000s concerning the 1999 Constitution? 18. When the CNO Council on November 13, 1990 voted to create under Legislative Act 11-90 a judiciary for the CNO, did the CNO Council have that authority? 19. Did the 1975 Constitution provide a JAT to authorise the creation of a comprehensive judicial organisation ranging from the District Court through the Supreme Court? 20. Has the Curtis Act ever been repealed by an Act of Congress? 21. Has the Cherokee Agreement of 1901 ever been repealed by an Act of Congress? 22. Is it possible for a federal administrative agency, such as the BIA, to repeal or nullify a federal statute without the action of Congress? 23. Did the CNO take any steps between 1976 and 1999 to conform to the acknowledgement and approved elements of the process outlined in 25 CFR 83.4 and 83.11? Between 1999 and May 12, 2021, has the CNO ever taken any steps to comply with the administrative acknowledgement and approval process set forth in the CFR? 25. Since the Constitution of 1999 was not adopted under the OIWA, the General Repeal Clause does not apply. 26. Did the Principal Chiefs Act authorise the creation of a government by the CNO? 27. Did the 1999 Constitution, purportedly nullified in 2003, constitute the formation of a legitimate government under federal law? 28. Did the Secretary of Interior, Deb Haaland, exceed her authority when she purportedly signed a document approving the 1999 Constitution? 29. Were any steps taken by the CNO to comply with the federal laws concerning the acknowledgement and approval of the tribal governments between 1999 and the signing of the approval by Secretary of the Interior in 2021? Issue 30 is blank, thank the Lord. I'll be interested to hear Warren Galt's take on this. Right, next we have a designation of record for appeal from District Court. And I don't know if you can tell from the reference above, but you'll see that this is the 7th case to be taken before the Supreme Court of the Cherokee Nation in 2022. A just tells us there were no transcripts from the District Court. B shows us that she hasn't submitted any exhibits. C, she has completed, as we see below, she's circled some documents on the docket. D is again about the transcript. Now, I did note that she did sign this, but she didn't date this. I don't know if that invalidates the document. And it's unclear from the certificate of service whether service was achieved. But as I say, these have been filed with the court. Exhibit A is where she circled certain entries in the docket, and the documents are therefore included in this document. And you'll notice she did circle one copy as a certified copy, which I skimmed through at about 1 minute 30 of this video. Right, on to the third document filed at the Supreme Court of the Cherokee Nation. As you can see, filed by Deborah D. Rogers on the 22nd of August, and it's an application for stay proceedings. The undersigned Deborah D. Rogers, proceeding pro se, respectfully moves the court to grant a stay of proceedings in the District Court of the Cherokee Nation, including but not limited to the jury trial schedule for August 22, 2022 at 8:30 a.m, pending an appellate review of the order denying defendant's motion to dismiss for want of jurisdiction dated August 12, 2022, in which the District Court of the Cherokee Nation denied defendant's motion to dismiss. Appellant then moved the District Court of the Cherokee Nation to stay jury trial proceedings, with the filing of defendant's motion to stay proceedings, which was denied on August 18, 2022. Appellant has filed a petition in error in the office of the Clerk of the Supreme Court of the Cherokee Nation within the time constraints of Rule 71.B of the Supreme Court, and that appeal is being made from an order of the District Court as described in Rule 75 of the Supreme Court, which also authorises the stay of an order of the District Court pending resolution of appeal. This application meets the requirements of 20 C.N.C.A 51 as noted in Rule 22 of the Supreme Court. This matter would present serious legal questions that need to be determined, and the appellant would suffer irreparable injury and irreversible harm, to include possible jail sentence and or penalties that the appellant wouldn't have if the motion to dismiss would have been granted by the District Court. This ruling denied the appellant due process and a fair trial under the 5th and 14th Amendments of the US Constitution by the refusal of the District Court to stay proceedings on the denied jurisdictional motion, resulting in an appeal to the Supreme Court of the Cherokee Nation or an appeal to the Federal Court by appellant. Wherefore the appellant prays that the court enter an order of stay as described herein. Respectfully submitted, Deborah D. Rogers, pro se. Under the penalties of the Criminal Code, these contents are true and correct to the best of the declarant's knowledge and belief, and that is unsigned. And again, I don't know if that invalidates this document. And then we go on to the certificate of delivery, and as this is unsigned, I'm unclear if she did hand deliver the document to the Cherokee Nation Attorney General and the Cherokee Nation District Court Clerk. As I say, I'm looking forward to Juan Galt's analysis of this, and maybe Merb's. We know she filed it at the Supreme Court, but has it been filed correctly and served correctly? Or did she not get a chance because she went into jail, where I understand by a source that she has to spend the next 6 days? I'll give a prediction to this motion, and it's denied. Thanks for watching.